Hey, Janice and Greg, check your email. I did a summary of the zoning administrator's position.
I've already
for
printed
this.
it out. I've already printed it out.
You've both got it? Okay, thank you.
Yes.
And would be on the record.
Hello? Hello?
Hello.
Hello? Hello?
Who is saying hello?
This is Nancy Allen. I'm trying to enter the Zoom meeting for the Board of Zoning Appeals.
That's where you are right now.
Okay. Thank you.
You're quite welcome.
Has the meeting begun?
It has
Not
not.
yet.
It has not been called to order yet.
Okay, thank you.
You're quite welcome.
Hi, Jim. Good. How are you doing? Do we have an attorney? Do we have an attorney?
Okay. Great.
Coach, been waiting another couple minutes. Go down, check the door and get started. We have this. Okay. I know that's something like that. Okay. We're gonna go over this side. And as a matter of fact, I think I may make a quick increase in distance. Real estate will slide that. Okay. Yeah. Yeah, if you don't mind. Please do that. Good instructor there, not slide tables. Hey, Megan, can you make it so Aaron can hear me? Okay, hey, Aaron. Unmute yourself. I need to talk to you for a second.
I hear you.
Hey, I sent out about a half an hour ago an email. It's a summary of my points. Did you get it?
I did, yes.
Okay, I just want to make sure you got it. Thank you.
Okay, thank you.
That's the Sure. You're upstairs and check for it.
He went to look, the one you gave him was for the historic commission, so he went to look for the other one. And I think he's one that's first.
Oh, wow. Like everyone.
No, I don't.
I rather set the procedure off.
Yes. I'll go back in.
Yeah, sure. Yeah, you can have it.
First, and the witness. I get the promise. And then the defendant being for responding to me, my witness, and public. And they be prosecuted. We don't have it at the moment, so God can move on also. That is a full procedure. Okay, folks. We are ready. Get us going. We're set, right? Correct. Second. Okay. All right. Good evening, everyone. My name is Steve Bachmiller. I'm the Hagerstown City Zoning Administrator. Under normal circumstances, the elected chair of the board would open the meeting. However, our chair resigned recently and we have not had an election to replace him. Therefore, the rules of procedure say that when that's the case, that the staff opens the meeting and conducts an election amongst the officers or the members for a presiding officer for tonight's meeting. So with that, I turn to the members of the board and open the floor to nominations. Everybody speak out at once.
I'll nominate Jim. Any other members?
Is there a second to that
Yeah,
motion?
I would second that.
Okay, Greg Deck seconded it. And any other nominations? With that, we'll close the floor and move to the vote. All those persons in favor of James Stauffer chairing this meeting signify by saying aye.
Aye.
Those opposed in like manner. Motion carries 4-0. Apparently the chairman didn't vote for himself. Okay.
Ready to go?
Ready to go.
All right. Welcome, everybody. First, I'll start with introductions. I'm Jim Stauffer, acting chair tonight. To my left is Laura Lowry. With us remotely is Greg Deck, Aaron Smith, and Janice Kelch, who make up our Board of Zoning Appeals.
You're going to need to speak louder through the mask.
Okay, sorry. With us also is Amy Haupt, who is the secretary tonight, and Steve Bachmiller, who is acting as is the zoning administrator. You're not acting as a member of the recording committee or anything tonight, right? Any other role?
Actually, in addition to my role as a respondent, I'm also going to be entering testimony on behalf of the planning commission.
Okay. With that, talk about the function of the board. The decisions in cases heard tonight are based on general and specific criteria as enumerated in the land management code. This is an administrative proceeding.
Get it real close.
As such, will be conducted just as if it were a court of law, except that we will not follow strictly the rules of evidence. Everyone who wishes to be heard on a particular case will be, and each of the cases will be heard in the order filed with the board. Tonight we have one case. Our procedure tonight will be first we'll hear from the individual making the appeal. Following that, we'll hear all witnesses for the appealant, and then we will do cross, followed by testimony from the defendant, and then at that point, any public or witness statements that have any bearing on the matter. We will then take this case under advisement and give you a decision within 45 days. You're welcome to stay after the hearing and listen to the deliberations that we have. The discussion is limited at that point to the board. Within 30 days of the date of the written decision and order provided by the board, there's a right to appeal. Any party participating in the hearing that is aggrieved by the decision may appeal to the circuit court. This is the 30 days after the date of the decision and order, not the date of the hearing. We have two rules which we will follow. First, only remarks that we will consider are those given from the witness chair under oath, and we ask that we confine all the remarks to the things pertinent to the case. So with that, let's call the case.
Okay, and Mr. Chairman, just a little bit of procedural stuff here for the public. We're all sitting here in masks. That has a tendency to muffle what we're saying. So if you're speaking, whether you're a member of the board here and or us as staff, the appellant, or those of you who wish to testify when it's your turn, please make sure the mic is right in front of you and you speak as loud, well, not necessarily as loud, but as clearly as you can, given the circumstances. And then the procedure will be, as the chairman mentioned, it would be the appellant would make their case first, and then call their witnesses, and we would be able to cross. And then as respondent, I would put on my case, and then they could cross me. And then after that, members of the public can also testify. Be aware though, however, that you will, if you do testify, you will be subject to being asked questions. And with that, we have administrative appeal. This is case Z 2021-09. It was postponed from the August 18th meeting at the appellant's request. This is an appeal to hear an application made by Wells House Incorporated through its attorney Zachary Kiefer Esquire for an administrative appeal of a decision made by the zoning administrator in the administration of the zoning ordinance determining that a use proposed for the property known as 670 to 672 Oakdale Avenue, located in the NMU neighborhood mixed use zoning district and in the Oak Hill Historic District is not permitted. Under normal circumstances for variances, special exceptions, non-conforming uses, there's a staff report that I would enter into the record. However, since I am responding to this case, there is no staff report.
Thank you. So with that, we'll start with the appellant. So first thing is if you could raise your right hand. Do each of you solemnly promise and declare under penalties of perjury that the testimony you're about to give this board shall be the truth, the whole truth, and nothing but the truth?
I do.
Yeah. So with that, do you want to start walking us through your case?
Certainly. Thank you, Mr. Chairman. My name is Zachary Kiefer, 19405 Emerald Square, Suite 2100, Office 202. That's Hagerstown 21742. As Mr. Bachmiller said, I'm the attorney for the appellant Wells House. Next to me is Christina Trenton, Chief Operating Officer for the Wells House. I'll let her give the her address there for the record as well.
This is his address, 124 Miss Baltimore Street, Hagerstown, 217.
So as I think we're all aware, this appeal is from a decision concerning the property kind of commonly known as the old Bill's Other Yard Sale. That property was a commercial, as Mr. Bachmiller mentioned earlier, a commercial use. It was a pre-owned used furniture store. I guess previously before that, it had some automobile history there as well. Based on what I could find online and by that Facebook, looks like Bill's has been closed for about 4 years since 2017, 2018. Wells House purchased the property back in January 6, 2021. As noted, the comprehensive rezoning that had been undertaken by the city of Hagerstown had rezoned the property from GC Commercial General to the neighborhood mixed use zone. I think that rezoning was finalized July 23rd, 2020. Again, changing the zoning to the current zoning of neighborhood mixed use. After the applicant bought the property, they submitted a building permit application for a large group home halfway house with some schematics, some notes as far as subcontractors, contractors, sort of their intent of the property. The response from the city, from the zoning administrator, sent in an undated email that I believe is part of the packet here on or about June 23rd, 2021, which I don't think there's any issues with the data delivery or anything like that. Essentially says that the use, what we're here tonight for is the decision that, quote unquote, the use is not permitted. So based on that appeal, I guess be a little difficult for the members who are appearing via Zoom, but I will hand out copies to Amy so she can percolate them as well. But all I'm handing out is just a copy of the table of permitted uses from the city's land management code. Simply showing that the, excuse me, the large group home halfway house is a permitted use in the NMU district.
One second. Do you want to check this in as exhibit for the,
Petition, the appellant's exhibit 1. So you can mark that appellant's exhibit 1.
thank you.
Thank you.
Mark it.
Based on that decision that the use is not permitted, the Wells House took an appeal, essentially walked through what their intent with the building permit, with the application was for, namely the level 3.1 residential low intensity program, halfway home, group home, that is regulated by the state, and it's part of the application material show sort of some of those characteristics, features of a 3.1 home that I think, although not administered by the land management code, I think it's good and indicative of what Wells House plans to do with the property. A lot of those certain characteristics and elements kind of match up a little bit. Just to highlight a few: preventing relapse, applying recovery skills, reintegrating into the community. Again, it's sort of that halfway home definition where we're not necessarily in a rehab facility, we're not also not at home, but sort of right in the middle. Based on that letter, or after our appeal, excuse me, which focused solely on the use not permitted component of the zoning administrator's first letter, we got sort of a secondary follow-up justification, which, you know, generally for the record, and, you know, to preserve any sort of issues for appeal, you know, we object to the issuance of that letter, the post hoc justification used for the denial. Generally, and it would be my assertion that the analysis should stop with whether or not the group home is permitted, that the large group home halfway house is permitted in the MU. It's a black and white, straightforward question, yes or no, and it is permitted. Based on that information, I would submit that the decision of the zoning administrator was an error and should be reversed. However, to address the second letter provided by Mr. Bachmiller to my client, we do want to go through some of the more minute points or more specific points of this denial that, you know, sort of followed again in a post hoc manner. First, before we get into those specific elements, I do want to bring to the attention of the board the purpose of the neighborhood mixed-use district. This is section E1B of the Land Management Code, specifically subsection 5, in that the neighborhood mixed-use district is to provide flexibility for adaptive reuse of old non-residential buildings in these areas. So again, going back to the history of the building, it used to be Bill's Other Yard Sale. Before that, some sort of automotive history, certainly before my time. But, you know, again, looking at what is permitted and the purpose of the neighborhood mixed-use district, it seems like this building is ripe for that sort of adaptive reuse of a non-residential building in this area. Going through, again, Mr. Bachmiller's analysis of the definition of a large halfway house group home, I think it's now sort of important to, not sort of, but it definitely is important to go through sort of what characterizes a group home halfway house versus a rehabilitation center, which is actually the notice that was put on the placards that are displayed on the property. Again, we dispute this characterization as a rehabilitation facility. Also, just for sort of clarification point, we're going to take that a little bit farther and talk about kind of the transitional recovery sober living home that this is also not. Again, the application was intended to be for a large group home, halfway home. Whether or not there was some question with the application, I'm not going to speculate to that at this point, but based on the denials and subsequent justification that we got, I do think it's important that Christina here provides us a little bit of background and context with what constitutes a group home versus a rehabilitation. So again, I'll turn it over to Christina for a little bit of education there.
Christina Trenton, Chief Operating Officer. The Wells House has been operating halfway houses within the city for 45 years. We have two facilities located at Baltimore Street and North Wilson Street, which is about 5 blocks from the current building at Oak Hill. We serve a population that has a primary substance use disorder. And so for those folks, what a halfway house is, it's self-contained. All the services are for the patients in that facility. There are not patients from other parts of the community that come and go from the facility. This is a home for people. A level 3.1 is defined by the American Society of Addiction Medicine as a halfway house, a group home, or other supported living environment that includes 24-hour staff and close clinical integration with services. We're licensed by the Office of Healthcare Quality as a level 3.1, which again, ASAM defines as a halfway house. Halfway houses are also required to be accredited. So not only is there a level of oversight at the state level, there's also a level of oversight within a national accrediting body, and there have to be standards that are met. Patients stay up to 6 months within a halfway house. They are stable when they get to a halfway house. They've already been through a 30-day program in which they received detoxification, or in this case, a rehabilitation center. There's no medical staff in a halfway house. All the patients have to be psychologically and physically stable. They do not suffer from withdrawal. Because there are no medical staff, all of these folks have already been to a rehabilitation center or inpatient drug treatment center before they get to a halfway house. Halfway houses provide 5 hours of clinical treatment in a week. They're staffed 24/7, which helps to minimize the relapse or continued use. It is a home-like atmosphere. It is somebody's home for at least a 6-month period, in some cases longer. Meals are provided in a communal dining room. There are home-like bathrooms. Chores are required. Patients must sign in and out of the facility. They have to be approved for overnight family passes. They are straddling the treatment world and reintegration. Rooms are personalized for our patients. We can serve up to 16 patients in a halfway house. And the goal is really to help a patient navigate between being halfway between treatment and community living. The clinical services and recovery residence components are provided together in a halfway house. And it's considered appropriate for individuals who need time and structure to practice and integrate their recovery and coping skills. Services facilitate the application of those recovery skills. It also focuses on relapse prevention and emotional coping skills. Halfway houses promote personal responsibility and reintegration of that individual into vocational rehabilitation, job placement, education, family life. Patients practice the activities of daily living, such as employment, financial literacy, life skills, while they are practicing newly acquired skills of being sober. They live together in a halfway house, in a home environment, in order to do that. Support is provided for the patient to self-manage their own medications. We employ peers that help assist with cooking, food support, and other residential support. Community and house meetings with patients and staff emphasize social bonding, cohesion, reinforcing the recovery concepts that they are practicing in their living environment and in the community. And these facilities are required by regulation to have office space for counseling and groups. There's also the need for space for ancillary services like telemedicine services, the space to secure patient medications for self-administration, and space for the 24/7 staff that are part of the residential team. This model of halfway houses is very structured, and there are specific regulations that have to be met and accreditation standards, and halfway houses that look like this are modeled all throughout the state of Maryland. They exist everywhere in the state, and they are all level 3.1 halfway house group homes for individuals with substance use disorders. If you contrast that with a rehabilitation center is a step down from a hospital. It's a very high intensive acute need. That is where somebody starts with a substance use problem that is actively going to experience withdrawal and needs managed medication withdrawal services and detoxification services. That is the initial starting point and initial stabilization. So patients that are starting there in a rehabilitation center have functional limitations in their physical and psychological health. The focus is on withdrawal management, stabilization of their mental health and their cognitive deficits at that point in time. Services are delivered by medical staff, physicians, nurses, registered nurses, nurse practitioners. The observations that take place are to help kind of medically stabilize the patient. That is why they have medical staff. Patients stay 30 days, sometimes they stay 60 or 90 days if they meet medical necessity criteria. They have up to 36 hours of treatment a week in a rehabilitation center. It's very intensive, and the day is structured from the moment a patient wakes up to the moment that the patient goes to bed. And everything is scheduled for them. If you contrast that with a halfway house, there's 5 hours of clinical care and support that's provided, but patients are living and integrating into the community. In a rehabilitation center, it's very institutionalized. It is an institutionalized setting. Doors are secured, and if a patient leaves the building, they aren't allowed to come back. They can serve up to 45 patients, so they tend to be larger facilities. And patient medication is prescribed and managed by that facility. It's dorm-style bathrooms, kind of multi-stall showers, toilets. Meals are often delivered on trays. It's a rehabilitation center. It's institutionalized, unlike a halfway house, which is a home environment. And just a further contrast, a transitional or sober living facility is a place that individuals live together to provide support to help them with long-term recovery. They come and go as they please with very limited requirements. There's virtually no staff. There may or may not be a house manager. It's not licensed by the state. There's no accreditation requirements. Individuals work and are integrated into the community. They receive sometimes other services in the community. But it's very much like renting a room in a boarding house, if you will. The stay can be as short as 1 week. It could be months. It's variable depending upon the person. There are also transitional and sober living facilities that individuals may start living in a facility like that only have a few days clean and sober. They've probably gone through withdrawal management, but they don't have up to 30 days in some cases. So that just is one, there are very clear and distinct differences between a halfway house, a rehabilitation center, and a transitional or sober living facility.
We're
Thanks,
for-
Christina.
Do we want to put this in as exhibit 2?
Exhibit 2, yes, Mr. Chairman. Thank you, Christina. And the board members, the last point I'd like to make and sort of touch on here is the emphasis in Mr. Bachmiller's letter of August 13th, 2021, that was in your packet, and his interpretation that the property in question does not constitute a home-like environment. We obviously dispute that characterization and for a number of reasons. The first being the large halfway home, halfway house, group home, per the land management code, permits between 10 and 16 residents. So just by a factor of that permission of 10 to 16 residents, there's no single family dwelling out there that's an 8-bedroom, 4-bathroom monstrosity of a single family home. It almost sort of forces or kind of pushes these larger group homes into a repurposed commercial building that actually has the space. Otherwise, if we're in here and trying to justify cramming 10 residents into a 4-bedroom house with 1.5 bathrooms, we get laughed out of the room, I would think. So, not to belabor the points that Christina so eloquently made, there is a home-like environment. There are the sit-down family dinner, irrespective of how far the kitchen is from the dining room. This isn't a walk through with your tray, any sort of mental impressions of one flew over the cuckoo's nest, with Nurse Ratched up there, applying the medicine and just rows of beds. That's not what is going on here. We have individual bedrooms, we have individual bathrooms. Just by necessity, a large group home is going to be a large building. So we think the emphasis, one, is misplaced on the home-like environment, and two, we feel that this building meets that home-like environment just by the fact that, it's going to be a larger building. There's nothing that we can really do about that. We are not sort of post or kind of patchworking this together. If you can see the plans for both the upstairs and the downstairs call for a complete renovation. So, this building it's an older building. It's been sitting there vacant for 3 or 4 years. So it does need a lot of work. That's what the building permits were for. Obviously, we have a lot of contractors that are going to come in, rehab the whole thing, turn it into this more family-like, home-like atmosphere. And just the point about the green space and everything, per the land management code, the minimum use yard requirements for buildings in the neighborhood mixed-use district, front, side, width, and they're all 0 feet with a 5-yard minimum setback or minimum depth for the rear yard. So there isn't a whole lot of green space or isn't a whole lot of room contemplated by the land management code for these uses within the city. So the fact that a home doesn't have green space, I guess that would sort of negate any kind of apartment, potentially some of the townhomes in the city, row homes, things like that. Again, I think the emphasis is misplaced on some of these features that, are kind of expected and common when it comes to a single family dwelling, but we're just talking about a different animal here with the larger group homes. And with that, I'll submit and turn things over to the board. And unless Christina has any other points or points of clarification, I thank you for your time and patience and consideration.
Thank you. Just procedurally, question directed to Mr. Buckland, cross before our questions or questions before your cross?
I don't think it matters.
Okay, so let's proceed with your cross and then we'll follow board questions afterwards.
Okay, I just have a few questions. So we have a facility here that has 24/7 staffing, correct?
Correct.
Okay. And you referred to the people who were living here as patients, correct?
That's correct.
Okay. And you said the stays could be anywhere from a month to 6 months, is that correct?
They can do.
Okay. And if you could explain to us a little bit more without divulging things that obviously you can't as being part of the healthcare community. The nature of the folks who come to and will patronize this facility, and for example, where was their last stop in the recovery process?
If I understand your question, as I said, all of the patients have a diagnosis. It's a substance use disorder diagnosis. That can mean a lot of different things. When you ask where their last stop was, I think I alluded to that earlier. Almost all of our patients have been in an inpatient rehabilitation center for at least 30 days before they get to them. Is that answering your question?
And let's see. The folks who would be at this facility, are they considered at that point out of the detoxification process and are in recovery and are trying to adjust to getting back into their previous life?
That's correct.
And one thing that was brought up is the zoning of this property, being that it's in the NMU zoning district, and it talks about the adaptive reuse of existing buildings. Staff will stipulate that is correct. However, we want to clarify that it assumes that the use itself is a permitted use in that zoning district. Looking at the chart that you provided, notice that it's like renting a room in a boarding house, serve up rehabilitation center. Okay, that would be a transitional / recovery housing. Would you view a boarding house as being a home-like environment?
It is someone's home, absolutely.
Well, in a boarding house, typically there's someone who is the keeper who's living there, renting rooms in their boarding house.
Sometimes, that's one model. In a boarding house, typically there's a shared kitchen, a shared dining room.
Steve, are you on page 2 there at the top?
I am, yes.
Fourth column?
Yeah.
Okay. That is in the column for the transitional recovery housing, sober living Oxford home, which we use again to distinguish from the group home halfway house.
And you're familiar with the definitions that are in our zoning ordinance. And we'll point out in our presentation later that the definitions in the zoning ordinance don't necessarily match up with what's in the COMAR for your licensing process. You need to figure out how to navigate both of those. How do you feel that this facility meets the intent of the definition of group home, halfway house, and alternate living unit for transitioning people back into their previous lives, as opposed to it being a rehabilitation center or a substance abuse hospital?
Sure, I think it's helpful, and Christina, stop me if I'm getting off track here, but the definitions of, well, we can start with the definition of a rehabilitation center, which specializes in therapeutic programs to assist patients achieve the necessary functional independence to return home, usually following an acute medical and surgical hospitalization, including detox for substance addiction. So I think by that definition, the rehab center is there to rehabilitate, to actually get them out of the door of the rehabilitation center. It's bed rest, it's detox. Again, the nurses, nurse practitioners, docs are coming around, checking on folks, as opposed to the group home where they get up in the morning, they have breakfast, they do their chores, and then they're out, out to their jobs, out to job training, school, which
they're already in the community at that point. If a group home or a halfway house, the person is in the community. They could return to the community as soon as they wanted to. It's the practicing of the skills and assisting them with return.
When people come to this facility, are they still chemically dependent?
As somebody with a substance use disorder will have that disease for the rest of their life. It is
That's
a
not my
chronic
question.
disorder. So
Are they still chemically dependent?
are you asking, are they currently using
detox?
drugs or alcohol? Yeah, I mean, they're not currently using drugs or alcohol, but yes, they have a diagnosis.
And,
Chemically dependent.
and I understand that addiction is a lifelong thing, don't get me wrong. I'm just trying to drill down to making sure we clearly understand where we are in this process, because where we are in the process affects how the zoning is applied.
Absolutely.
So, so people who are living there, they have detoxed essentially. They are out of that first stage where they're no longer in a withdrawal situation, that kind of thing, correct?
Did you also ask about substance abuse center in your previous question, before I started rambling on about the rehab center? Just because a note on that too, the outpatient substance abuse, naturally by its name, provides an outpatient medical office for counseling, treatment of substance abuse, which may include disbursement of addiction treatment drugs. Christina, correct me if I'm wrong, we're not having any outpatient medical treatment there, and there's no disbursement of addiction treatment drugs as far as the, remind me, what are those again?
Suboxone, Vivitrol. No, they are not. All the services are self-contained. It's not an out.
So there's no distribution of, well, actually, it sounds like from what I heard earlier, there is distribution of maintenance medications, so it's like to people who live there, correct?
Just to the people that live there.
Right. So they've gotten a prescription from their primary care physician, some sort of care doctor. It's a prescription that would be in their kit, their cabinet, just like something for high blood pressure, allergies, things like that. It's not sort of that higher level detox for substance addiction type, or not detox, but the medical treatment like Suboxone.
Vivitrol.
Okay. And just one last question. In your materials that you're providing, do you have anything that you're offering that compares your intended clientele to protected populations who are protected by fair housing laws through the protection of persons with disabilities?
Are you asking, are they a
I don't-
protected population?
Do you have any information that you're willing to provide demonstrating that you feel that they fall under protected classes within federal and state law?
We don't have any specific information that we provided, though. Yeah, Steve, per your paragraph 9, the post-treatment transitional housing is protected class. So, I think there are some protections there based on the disabilities that the residents endure. But again, to answer your question pointedly, no, we don't have any additional information on that point.
Okay, that's all I have. Thank you.
Okay, so at this point, we're open for some questions from the board. So I'm going to start with the first question. One of the comments made and the documentation here references the facility on Locust Street. Is that currently considered a rehabilitation facility or a halfway house?
It's a licensed halfway house.
Okay, and it has residential areas that would meet sort of the same requirements that we're talking about in this facility?
That's correct.
3.1.
It's a level 3.1 halfway house.
There were a couple of references made to no medical staff being in the facility that you're proposing. But one of the questions I have is the medications that are being given to the people that will be staying there. Do they hold those medications themselves, or are those held by somebody else and given to them as needed?
So they get the medications for their physicians, whoever they're receiving their somatic care from. The medications are in a safe, locked bag that the patient has a key to. The patient has to self-administer those medications. The bags that are locked by the patient, they are then locked behind closed doors. There's a set of regulations that have to happen for the protection of the medications. The patient can choose to take their medication or not take their medication. They're completely self-sufficient in that area. It's just we have to provide a protected space for the medication when you have that many people living together.
So do they have direct access to get the medications themselves, or they have to ask for permission to get to those medications?
They would have to have a staff member open the door, and then they have the key to their individual medical bag.
Almost like a lockbox.
Yeah, like a lockbox.
Could you describe sort of what you envision the ceiling looking like in this facility? The reason why I ask is because sprinklers are uncommon in what you consider residential facilities. So what do you plan to do with ceilings? Is it drop ceiling, drywalled in?
It would be dropped.
I'm going to see if anybody else wants to ask some questions.
I have
Certainly.
just a couple, I have a couple questions. First of all, if the lady could maybe pull her mask away from her face when she speaks, because it's a little muffled. And so I don't quite understand, or either get closer to the mic if you please. But I did have a question about the medication. And now that you answered, they can choose to take the medication or not. Now, sometimes that can be a situation. Wouldn't that cause a situation if they really needed it and chose not to take it? That could be a little episode going on. And so can you address that?
Yes, ma'am. We have a clinical staff that deal with these challenges all of the time. And that's one of the reasons why patients are with us, to practice those activities of daily living, learning to take their medications, learning to self-manage symptoms. And so when that doesn't happen, then we have clinical interventions that we work with our patients on motivational interviewing. And if they're experiencing a lot of symptoms with the medication, we have releases of information to talk to their doctor to see whether or not there are alternatives to that. So we do a lot of work in those areas with our patients. It just depends on the individual situation.
Okay, thank you. And I hear you much better. Another question, I believe I heard you say where tours were required or are required.
Could you repeat that?
Tours, T-O-U-R. Okay, it was a little muffled when you said that. So tours are required throughout the source of the time in the program?
Yes, ma'am. Just like in any home-like environment, I think those of us that have children have always required that our children help with household chores. It's no different for our patients collectively as a group. They all have assigned chores each and every week that they're expected to help kind of keep the community in the house clean and kept up, and the facility ready for the next day after a busy day of lots of patients in and out.
Okay, and from what source do the individuals come from? I mean, are you working with the state of Maryland, or where do the residents come from?
So the residents come from the Massey unit in Allegheny County. It's one of the 30-day treatment centers.
What is the name? What is the name of the unit?
It's the Massey unit.
Okay.
They also come from Awakenings, which
Okay.
is right in downtown Hagerstown. That too is an inpatient rehabilitation center. They come from Mountain Manor Treatment Center. And we do have some patients that come from Washington County Detention Center.
Okay. And you have 24/7 staff in place?
Yes, ma'am.
That's all my questions at the moment. Thank you.
Greg, do you have any questions?
Jim, just a few questions. I'd like to ask, what are the professional credentials of the staff?
So for the clinicians, we have addiction counselors, and they range from trainees to supervised addiction counselors, associate addiction counselors. We have licensed professional counselors. We have licensed graduate counselors. We have licensed graduate social workers, and I am an LCSWC, so I'm a licensed clinical social worker. So there's about 8 different certifications that one could have to be a clinician in a residential facility like ours.
Let me add on to his question for a second. Do any of those staff members with those accreditations, are any of those deemed medical accreditations, or are they all social?
They are all clinical counselor or social work accreditation.
Thank you. Also, I'd like to ask, is stay at the facility voluntary or is it court ordered?
So we definitely have some folks that come to us because they have court mandates, and that's not uncommon in a population with a substance use disorder. But the large majority of our patients come because they want help. They want to make some sort of difference in their substance using history.
Thank you. That's all I have.
But would they come from any other location other than the ones that you named?
They could. As a state Medicaid provider, we can't turn someone away from receiving treatment services. So they could. I think when Zach and I looked at the numbers, we had maybe 5% of our patient population that came from an Eastern Shore county. And I think it was maybe 3% that came from Baltimore County, Baltimore City, Howard County, in that region. The rest of our folks really come from the Western Maryland catchment area.
Okay, but it's a certain level that they come in at, is that correct?
Could you clarify the?
They have to be in a certain, I mean.
They're stabilized when they come.
Okay, they're stabilized. So what
Definitely.
happens if a person wants to come in that's not stabilized?
We don't admit them.
Okay, I was just asking.
Yes, ma'am. We have a pre-screening process in which we look very, very closely because we don't have medical staff, and that's a huge liability for us. We don't have the capability to treat individuals that are unstable.
Okay, so the medical staff, so why don't you have medical staff?
Because we are not required to for our level of care. It is not a medical level of care for substance users. That's the number one reason why we don't. We partner with family health centers and we make sure that all of our patients are enrolled in the federally qualified health center so that they have services, but we don't have medical staff on site.
So have there been problematic areas in the community in certain other locations in which you've had these homes?
When you say problematic, like, could you give me an example of what?
Trouble, violence, disturbance of neighbors? That would be my question.
We have not. We have not had those issues with our patient population.
Okay. Thank you.
Laura?
Okay, yes, Christina, I have a question regarding some of the services that will be provided to the residents, the patients. You had mentioned that some of the life skills that they will be learning, there will be classes for job skills, art and music therapies, financial literacy. So are there individuals that are employed there that will be providing these services on site?
Everything is provided on site.
Okay.
Yes, by our clinical staff, and then our peers also. We have a peer case manager that assists people with things like driver's license and social security cards, or helping to put together a resume, fill out a job application.
Okay. Okay, very good. And you had mentioned that their stay could possibly last up to 6 months. What determines the length of their stay? I mean, is there a certain program that, when a patient comes in, that you evaluate and determine the programs that they may need to complete in order to be better suited to, be back integrated into the community?
In the insurance world, there's this thing called medical necessity criteria that the payer says that if you're not sick enough to meet this level of service that you need, then we're not going to pay for it, and therefore you don't qualify for it. It's the same concept in our world. So people have to be at a level of their, the kind of change in the change process, if you will, and their kind of relapse, their ability to apply relapse prevention skills. Individuals that take a long time to kind of work through and cope through cravings might need to stay longer. So it really depends, but if you think about what happens in the medical world, it's the same for us and our patients. I hope that answers your question.
Yes, it does. Thank you.
Mr. Chairman, I have a couple of quick redirect questions, if that's okay.
Sure, that's okay.
First one is, I just want to note for the record that in their comments, they were referring to treatment services that are being provided. I was wondering, the building permit application was quite big and doesn't really talk about what the proposed use was. It doesn't identify it one way or the other, give it a label. It just says that it is a replacement, unquote, for your facility at 1 Locust Street. So the intention is to close the Locust Street facility, is that correct?
To sell it, yes.
To sell it. Okay. And could you explain to us the nature of the Locust Street facility, how many rooms it has, how many people it currently accommodates, things like that? How many people per room, that kind of thing?
So I'm not sure how many bedrooms, I'm sorry, as a female, I don't go into the male houses. But suffice it to say that we have about 16 people there. We have several staff members as well that work the shift work in that facility. Locust Street is a licensed halfway house, a level 3.1 with the state of Maryland. And so the services are the same as what's described in the halfway house section of the document that we provided. 5 hours of clinical care, and individuals work in the community. They integrate with their families. They have visitation with their children. They go home for weekend passes. They come back. They receive all the life skills services, as well as, you're correct, treatment services are part of a halfway house.
Okay. And the overall organization of Wells House, does any part of your operation as part of its business model do the first step, the detox process of any of that?
We do not.
Anywhere in your business model within the city of Hagerstown or anywhere else?
We do not.
Okay. And then the next question I have is regarding the zoning of the property. In my interactions with Mr. Peacock in trying to get this narrowed down, he was concerned because they were specifically looking for property that was zoned CG, which I found interesting. If their intent is only to do a large halfway house, which they could do in a lot of zoning districts, why you all were looking for a property specifically in the CG zoning district, which does allow the more intense type situation, or is this? I find that peculiar.
So I can tell you the reason why is because we weren't aware of the zoning changes and the reclassification and separation of rehab center and the halfway house group home is a new classification. So when we went into this and we were looking at the city maps on the website, where we thought we were looking at the right city maps, the only way we could locate our North Locust Street halfway house in that building is if it was, at that time, our understanding was a CG.
Okay, and just for the record, the text amendments that went into effect that started regulating these things more directly went into effect in 2018. So that's 3 years ago. Now, keep in mind, there's a difference between the zoning map, looking at the map, finding out what the zoning of the property is, versus the actual text of the ordinances. And these regulations have been in effect for 3 years now.
The group home and halfway.
Those regulations have been, yeah. But we found, I was wondering why, and what you just explained, if you could develop on that a little bit, because I'm not clear on why that would have driven someone to specifically look for the CG zoning district.
Well, I'm not going to speculate as to what Mr. Peacock, and I did read those emails and conversations, and really in sort of those discussions with the Wells House, they're not looking at the zoning ordinance and zoning maps like you and I are on a daily and weekly basis. And so I think it's fair, it may be curious, but I think it's fair that someone whose profession is not tied to analysis and interpretation of both the zoning map and the ordinance be an expert and not have a chance to be incorrect. Obviously, they reached out to council because there were some issues, because there were concerns as far as interpretation and things like that. But the back and forth on the adequacy of, or whichever zoning map they were looking at, and the interpretation of the zoning ordinance, it is what it is. It's an interpretation by a citizen. I don't think that any intent should be read into it as far as trying to shoehorn a rehab center into a neighborhood mixed-use district, or calling it a halfway house group home, when in reality it's intended to be a rehab center. I mean, they couldn't get the 3.1 certification if they were doing the things that are defined as elements of the rehab center. And ultimately, if the inspectors, the planning and the zoning inspectors were walking by and thought there was some sort of zoning violation, then we get popped, and that's just a whole other can of worms as far as zoning violations and things like that. So to the extent that a layman may have been a little mistaken in the analysis, interpretation of the zoning map, whether he had the right one or not, and the land management code itself, I wouldn't read too much into that. I mean, we're here with an application and a layout and justification for putting a principally permitted use in the correct zone. And that's no doubt about it, Steve. There was a little bit of vagueness in the materials, but ultimately, I don't think any sort of inference that we're trying to call a rehab center a halfway house is accurate.
All right, I'm still a little vague. Can we boil it down to a sentence of why CG was specifically sought?
Outside of what I said, I'm sorry.
Because they thought that was a
that's what we
permitted
thought.
use for a large group.
Right.
They were wrong.
But a large group home is permitted in other zoning districts, which they weren't looking for.
I'm sorry.
So there's no contact was made with the city for verification of that?
No, man, it was actually, I think it was a bit of dumb luck that it just so happens that even though they were arguing or thought something was CG, that turned out to not be the incorrect underlying zoning for the use they wanted. It turns out, lucky enough for them, that they bought a property that not more than a year ago was actually zoned correctly for the use they wanted. Again, this is a significant part of my work. It's obviously what Steve deals with on a daily basis. This isn't, sometimes it's not as clear as just kind of doing a quick Google search and pulling up and getting a confirmation. There is a level of analysis, and if I can kind of pat us on the back, a little bit of expertise that goes into this too. It's not the easiest thing to navigate if you're not sort of steeped in that to begin with.
The last question that I have is, the question came up of law enforcement issues, and you all say that you haven't had any issues with that. I don't have any information here at my fingertips that says one way or the other. But if this board were to decide not to deliberate tonight, to hold it over to another meeting and leave the record open, would you object to the records of the Hagerstown Police Department and our Code Enforcement Office being entered into the record before they enter the deliberations?
Well, let me be clear that the question was also about violence or violence with neighbors.
I didn't hear what you said. Could you repeat that, please?
That I believe the question was about whether or not we had issues with violence and
Right.
violence.
I didn't hear your answer. I heard the question. I didn't hear your answer.
And my answer had been no, we did not have issues with violence towards neighbors or violent patients.
And that opens the question to compliance with the law. And I'm just wondering whether or not you all would be okay with the records of the City of Hagerstown Police Department regarding your existing facilities being entered into the record?
To the extent. that
Maybe
they're
no,
relevant.
maybe absolutely nothing for all I know.
To the extent that they're relevant and may not necessarily, it could be anecdotal, they're not necessarily even the same residence, it's sort of, I would object to, again, it's relevance and truthfulness towards the matter at hand, but, if you're gonna submit if you're gonna submit those materials, my objection's noted in the record.
I think it's your side of the table that entered into the record that there hasn't been a problem with, I'll make sure I'm clear, violence. So I just want to make sure I didn't enter that. I didn't bring that up. It was in response to a question from a member of the board. And then that was the response that was provided. So I just wanted to check to see if you're okay if we essentially verified that.
As long as you're very clear about whatever the police responses are, that it's not violence. There could be police responses.
For things such as,
If somebody is threatening to commit suicide, that's an immediate crisis call.
that's fair.
We do not have medical staff on site. We have actually had crimes committed on our property, and police have responded.
That would be fair too. I just want to make sure that we're clear on that. That's all. That's all I have. Thank you.
So I just have a couple follow-ups as well. So one question that I have is, assuming that everybody has a job description of some sort who's going to be working at this facility, does any of the staff members there have a designation in their job description that deals with security around the facility?
We do not have a security. We
And-
have 24-hour residential staff. Most of them are what we call paraprofessionals. Many of them are people with lived experience themselves or have an interest in the human services and helping field. And so they don't necessarily have backgrounds in security, but we have very clear protocols about what's to be done if there is a problem. And if there is a significant problem that happens, then we're very clear in how we use our community resources to be able to get help to deal with that. Not unlike any other business in this community.
So let me ask it a different way. Nobody has a primary job description duty or has an understanding that it is part of their primary job duty based on what's been communicated to them to deal with security incidents with the people that would be residing here?
No, because our goal is substance use treatment.
Is it required by the state?
It's not required by the state.
Just based on the structure of the facility, there's a large number of bathrooms, which is understandable. But are all of those bathrooms single occupant use? None are shared where there's multiple toilet facilities and things like that?
I think there are a couple that would be shared, if I recall.
Oh, so do you mean like multiple shower heads, multiple toilets?
Yes, shared at the same time.
No,
I get that they would be adjoining, multiple people might have access to them, but not at the same time.
correct. They're single use bathrooms.
Okay, and then going back to something that was stated, there was a statement made that alluded to, I'm going to paraphrase, that there's some vagueness in some of the documentation around some of the zoning things and may not always be understandable by somebody. So based on that language that was used, you would expect a facility like this, typically in most commercial facilities, somebody would contact the city to ask about anything that would be vague or questionable and verify that what they're looking to do is allowable. Did anybody contact the city at any point in time to ask any questions about putting this facility in this, or putting this use within this facility? Or did it only come out through the submittal for permits?
So prior to putting the permit in, no. We relied on the website and the maps and our understanding of it.
Have you opened any other facilities recently in any region within the state of Maryland or within Washington County or Hagerstown?
No, I guess the Baltimore Street facility would have been the last one, and that was a number of years ago. It would not have been recent.
Anybody else on the board have any follow-up questions?
If I ask one quick direct follow-up,
Sure.
it'll be real short. With all the money that it costs to purchase this facility, and all the money it's going to take to renovate it, why didn't Wells House seek out a letter of zoning approval from this office to give you a paper trail to verify that the city concurs that what you're proposing to do is permitted there before you purchased it, which is typical business practice for across the board, not just
For
in your
developers
field.
perhaps, and people that have experience buying properties and doing this work, absolutely. It isn't for us. It's not.
They
something
wouldn't be
that
the
we-
first client to come to me without having done their expected due diligence that you would expect from a more seasoned property investor, developer, contractor, what have
Just want that on the record.
you. Certainly, absolutely. I stipulate to that, of course.
Okay. All right, thank you.
With no follow-ups from the board and nothing else from the city representatives, at this point, we'll close the testimony. And at this point, then,
Mr. Chairman, might want to ask if they have any additional witnesses.
sorry, I would close your specific testimony, but do you have any other witnesses to speak on behalf of your organization?
No, we don't.
Okay. Okay, so at this point, then we'll move into, I believe the Mr. Buckner acting as the defendant, the proper term to use in this case?
Respondent.
Respondent. Yeah.
Not a defendant.
Respondent.
Never will be.
Do you solemnly promise to declare under the penalties of perjury that the testimony you are about to give this board shall be the truth, the whole truth, and nothing but the truth?
I do.
Could you state your name and position?
Stephen Bachmiller, Hagerstown City Zoning Administrator, 1 East Franklin Street. I'm here as the respondent, but I'll also be entering material into the record later as a representative of the Planning Commission with their position on this situation. I've passed out to members of the board, emailed to the ones who are Zooming in tonight. I've provided a copy to to Mr. Kiefer regarding our position on this. And we just want to be really clear that the way the communication had been handled on this up to this point could have been a little bit better on both sides. When I did the initial letter to them, informing them of their problem, I didn't put a date on it. But we did receive their appeal within 30 days. I verified it verified when we sent it. And they did get it within 30 days. So the city has no issue with that timeliness of appeal. Also, based on the vagaries that we felt we were dealing with, I ended up responding with a somewhat also vague response as well, telling them that this use is not permitted, but then we didn't say what it was. And that's what inspired the follow-up email that was in my zoning administrator's package from August. Hold on 1 second here. 16th, is it?
So I believe they're dated either the 13th or the 16th.
13th, thank you. So I was clarifying that. You know, obviously it's going to be difficult for the applicant. We feel we have to provide fair opportunity for everyone, and we thought we should clarify our position in order for the appellant to adequately prepare their position on this. It's kind of hard to say the zoning administrator didn't, we disagree with the zoning administrator, but he's not telling us what we're not doing. So that was what generated that letter, which they expressed some concern with at the beginning of the situation. What I would like to do is I would like to go through the materials that I handed out earlier in this meeting and just kind of walk everyone through them, because admittedly, this is a very complex issue. We're dealing with not necessarily contradictory, but different definitions, which the applicant needs to navigate through in order to achieve their goal. And so I want to make sure that we're clear on these things. So again, I'll just walk through our position statement item by item. First, the property was previously zoned CG Commercial General. The property is now zoned NMU, Neighborhood Mixed Use. This has been since July 23rd, 2020. Prior to that, public hearings were held. The property owner at that time was notified of the proposed change of the zoning of the property. And this process went on for months prior to July 2020. The appellant purchased the property in very late 2020, or it sounds like it was like right after New Year's, it was officially put into the land records. But the property had been zoned for, or rezoned to neighborhood mixed use for close to 6 months prior to the finalization of their sale. Number three, the appellant applied for a building permit for renovations to the subject building in May. The permit was routed to the zoning administrator and myself for review and approval. The only description of the proposed use was the building will be renovated and used as a replacement for our Locust Street facility. This does not describe the proposed use or provide any description of what the use of their Locust Street facility is. So I was kind of operating in a vacuum as far as what that was. This also is a little bit weird because over the years, we've had a rather difficult relationship with Wells House for a variety of reasons, real or perceived. And as a result, when we see something like this, we get very cautious in our analysis of the situation. So we started asking questions, especially given how vague the description was in the building permit application. I'll move on to number 4. There are 2 relevant definitions in Article 3, the definition section of the Land Management Code. One is for a group home, halfway house, and alternate living unit. And it talks about people with disabilities and also in a home-like environment. And then another definition of rehabilitation center. There is no official definition in our codes for a hospital per se. We just use the standard understanding of what a hospital is. Maybe we should put a definition in, but a hospital is a hospital. So these definitions are the ones that are in the Land Management Code. These are the ones that govern me as the zoning administrator in administering the zoning ordinance. These definitions differ, I'm not going to say they conflict, but they differ from the definitions that the state uses in licensing the various forms of healthcare and treatment facilities. It's incumbent upon the applicant to figure out a way to navigate both of those. We readily acknowledge that our definitions are different than the county, the state, but we are serving 2 different missions. And by complying with both, they still could find locations within the city of Hagerstown to do the proposed uses as we understood them. Number 5, the land use chart found in section Z of the zoning ordinance permits the following uses as they relate to the CG and the NMU zoning districts. Alternate living units, small group homes, and small halfway houses are permitted in both of those districts. Large group homes are permitted and large halfway houses are permitted in both of those districts. Ambulatory healthcare services, with the exception of outpatient substance abuse centers, are permitted in both of those districts. And hospitals, including psychiatric, substance abuse, and specialty hospitals, are permitted in the CG zoning district, which they were looking into, and not permitted in the NMU zoning district. These textual terms were amended in the zoning ordinance in 2018. They've been on the books for 3 years. And included the creation of also a new zoning district known as the INST, the Institutional Zoning District. Facilities for the treatment of persons with alcohol and substance addictions are permitted in the CG, CR, POM, INST, and IMU zoning districts. There are 5 zoning districts in the city where they are permitted. Number 6, the appellant purchased the property believing it was zoned CG, zoning that they were seeking. Therefore, it can be deduced that they knew the zoning that they needed for what we understood their intent to be. Number 7, the definitions from the state COMAR cited by the appellant are state definitions for licensing purposes. They are not part of the Land Management Code, and as such, as the zoning administrator, they do not impact my decision. I have to read the ordinance as it is written. Once a prospective developer has determined what type of facility they seek licensure from the state using the state's definitions, they then need to review the Land Management Code and the zoning ordinance for what permits that use for what districts that it permits those uses within the city, using the city's definition. So you end up having to navigate 2 definitions to get to where you want to be. None of the uses that the state licenses is prohibited within the city, but are directed to appropriate zoning districts. All of these uses that we're discussing and how we're interpreting them, whether it's a small group home, a large group home, a rehab facility, or a hospital, all of those uses are permitted somewhere in the city. The city does not preclude them within our zoning code, but they're assigned to certain zoning districts. Number 8, the treatment of alcohol and substance addiction is not a protected class under federal or state law. The city can and does direct such facilities to appropriate zoning districts by permitting them in all 5 zoning districts in which hospitals are permitted. Number 9, post-treatment transitional housing is a protected class. As such, bona fide halfway houses, as defined in the city's code, not necessarily the COMAR for the licensing purposes, where persons who have previously received treatment for substance addiction and are in need of true transitional housing between their treatment and their return to their homes and communities are treated per superseding law, similar to comparable residential uses. So basically, small ones, basically anywhere you can have a house, you can have a small group home. Any place that allows apartments, you can do large group homes. Number 10, the city has had ongoing issues with outpatient and residential treatment facilities over the years as they were permitted in residential areas, and unsupervised clients would create problems for the surrounding communities. And again, I'll qualify that by saying real or perceived. The zoning ordinance amendments adopted in 2018 were done to address this issue, and in doing so, significant research was conducted to ensure whatever the city adopted was compliant with superseding state and federal laws to protect post-treatment persons in recovery who are considered disabled per law. The city is confident that the ordinance as it exists is compliant with state and federal laws protecting disabled persons. But people who are currently in treatment are not so protected. That's different. Number 11, the proposed plans for the renovation include the following features or elements. 14 bedrooms, most of which are quite large, typically in the range of 12 by 18, which could easily be configured to accommodate 2 or 3 people or more in each room. B, 4 rooms being created previously marked unused. Never received a building permit for a complete fill out of a building where people are creating rooms that they don't know what they're going to use them for. C, 5 offices for staff. D, 1 kitchen measuring 336 square feet and seems to be segregated away from the areas accessed by patients and residents, implying an institutional environment where meals are prepared. E, a loading area, several storage rooms, and no explanation of what is to be stored other than some general reference to other uses, perhaps other elements of their business model within the Wells House larger frame of operation. But that's a presumption on my part. F, there are only 6 parking spaces on the property. G, there is no green space on this property anywhere. H, living or group rooms measuring 1,425 square feet, 414 square feet, 792 square feet, and 700 square feet for 16 people. 1,425 is the footprint of a pretty reasonable middle-class house. I, a laundry room measuring 187 square feet. Now, if you put all these together in a facility, there's no home-like environment I've ever been associated with. And if after they did this, let's say 20 years from now, they decided to move the facility, close the facility or move it somewhere else, I think they would be very hard-pressed trying to convince any purchaser that this is a home with the size, the configuration, the rooms, et cetera. If the appellant is attempting to call this proposed use a halfway house or transitional housing, I want to be clear, as defined in our ordinance, not the state's ordinance. Staff has determined that this does not meet the definition as found in Land Management Code for the following reasons. 1, it is clear and apparent in institutional configuration. This is structured more as a dormitory or institutional use and not like a home environment. The zoning administrators determined that this does not meet the definition of a halfway house as defined in the Land Management Code. Number 2, by its configuration, it gives every indication that the intended use is as a drug treatment facility and not as post-treatment transitional housing for those who've already received treatment or are halfway to returning to their homes in prior lives, just given the intensity, the amount of staff, et cetera. And as configured, a 14-bedroom, 5-office institutional kitchen facility with storage and unused rooms existing in a building built for and initially used as a car sales and repair facility is not a home-like environment, nor should the appellant determine to cease the use or move it elsewhere, be rented or resold as a dwelling. I don't think there's anybody who would look at this and call it a home-like environment as well. The zoning administrator does not take the position that a large group home for up to 16 persons in post-treatment transition could be installed at this location. We're not arguing that point. However, as configured, this proposal does not meet the definition or common understanding. 4, it is important not to confuse or blur the difference between COMAR regulations for licensing and the definitions in the Land Management Code. And then lastly, I do this with any administrative appeal that I defend in front of you. The role of the board is to hear appeals and determine whether the zoning administrator made an error in his understanding of the zoning ordinance. The authority to interpret the zoning ordinance is vested by the Land Management Code with the zoning administrator. The board is not a board of we want a better opinion. For the appellant to be successful, the board needs to determine that the zoning administrator committed an error in understanding and applying the ordinance. Otherwise, the board should defer to the zoning administrator when an interpretation is a debatable matter. And the last thing that I want to enter into the record is I received a phone call recently from a local architect who I will not specifically name here. But I was asked about questions of group homes, large group homes, et cetera. And because he had a client who already does business in the city, who was looking to do a large group home for about 30 people, and they were looking at raw land sites. And my response was, so Wells House is possibly looking at building new somewhere. And I got no response on the other side because he had to protect his clients. I found the timing of that rather curious, that they're looking for to possibly, or somebody is looking to build a facility for as many people as there are for 2 people for each bedroom that is in this particular facility, and the bedrooms are still quite large. So the city's position is we have to be extremely careful with this particular proposal because of the long history of how these uses have impacted the city. We have amended our code specifically to protect both the rights of the people who live in transitional housing, but also the rights of the community as a whole. And we want to make sure that these things are very clear. And again, given our rather difficult relationship over the years with Wells House, it behooves us to be very cautious in our approach.
One quick question. Based on how this was distributed, do we want to put this in as an exhibit
Yeah,
specifically?
I'll take that respondents 1.
Does the appellant have questions you want to ask?
Yes. Mr. Bachmiller, is this the first Bay building permit application you've ever received in your office?
Oh, no, I get them all the time.
And generally, is every Bay building permit rejected?
Just for the mere vagueness, no. What we would typically do is we would reach out to the applicant and try to get more information, which we did in this case.
When you do that reaching out and points of clarification, does that come before, during, or after your letter, a zoning determination letter to come out?
Typically, we wouldn't do a zoning determination letter in this particular case, knowing that would probably be contentious. We provided a letter in this case. Oftentimes, somebody will give us a verbal, we'll enter a note into the record if it's something routine. Again, we receive This year, we expect to receive somewhere in the vicinity of 4,000 building permit applications this year. Not all of them are going to be gems as far as completeness goes. So a lot of times we call, we'll make a note of the record. But given the potential for this particular application, we want to make sure that we got it in writing. And we reached out to Wells House and had some conversation with Mr. Peacock. And those conversations resulted in the letter that I prepared.
And Mr. Bachmiller, have you ever lived with 10 to 16 other people under one roof?
No, I have not.
Would it be fair to say that generally what may be considered not home-like for less than 10 to 16 people under one roof could potentially be considered home-like when you have that many people living in one dwelling?
Not as I view this particular configuration. And I want to be very clear that we're not saying a large group home is not permitted at this location for people who are in post-treatment halfway situations. But when you look at this facility and everything that's going into it, show me that it is, essentially. Because again, I don't think one day when this is configured this way, one day when it's vacated by this user, nobody is going to call this anything remotely close to an home-like environment. It's more of a dormitory or an institutional environment, from my perspective as zoning administrator.
And again, you're refusing to give the name of the architect that called you,
That's correct.
and this architect, who shall remain nameless, didn't give you the name of his or her client.
He did not. He specifically said that he had to protect the name of the client. I respect that. But I found it very curious because we almost never get a request about someone doing a greenfield raw land build of a large group home or even larger than that, because they were expressing 32 potential residents or low 30s, somewhere in the low 30s. I found the timing rather odd, because I don't think I've ever been asked that question in my 18 years here. Hey, I'm looking to do to build a large group home, brand spanking new. What zoning districts do I need to find for this many people?
Would you characterize that conversation with the architect as a little more informed and pointed in their questions than you would your conversation with Mr. Peacock or the Wells House?
I would say it was more informed, but it was very to the point. It was just a single question. I'm looking to do this. Where can I do it? That was pretty much the end of it.
And in your 18 years, this is my last question. I'll rest, but in your 18 years, have you ever seen a overall housing market like this, with the demand for housing, building permits, general development in the city of Hagerstown?
It's as busy right now as I've seen in my 18 years here.
That's all I have. Thank you.
And I do want to clarify that when it comes to this site, if the users are as protected classes post-treatment, this site is not necessarily not permitted for that use. It's the configuration that we have the issue with, if it is determined that way and it's not a treatment, this actual treatment facility.
Thank you.
So I've got two questions. First one, could you clarify again, when was the call with the architect that you referenced?
It was within the last 4 weeks.
Okay.
I think it was since we had the last hearing for this previously scheduled, and then it was postponed. It was sometime in the last 4 weeks.
You referenced that there's been a difficult relationship with the Wells House, and I'm paraphrasing what you said. Could you give some examples of what that was? And specifically, were any of those related to any zoning or any issues that would have come under the purview of the planning and code enforcement?
I can say I spoke with our Chief of Neighborhood Services, Paul Falk, and he says the city has a long history of various forms of code violations with Wells House with their facilities. The property that they have on Locust Street has been there since like the 1970s or so. And we're not exactly sure. I referenced to it as being a non-conforming use in my letter, but really, we're not even 100% sure that it probably is. But over time, we found that whenever the city has inquired to get a grasp on exactly what Wells House does, we are responding with the bare minimum absolutely necessary, essentially. We didn't feel there was a whole lot of cooperation. Plus, we do have a long history of many various code violations on the site. I don't know if there's any outstanding currently at this time. But I asked Mr. Falk, and I said, what's our history with Wells House as far as code issues go? And he said, oh yeah, we've had a number of them over the years. And again, my conversation with Mr. Peacock was framed from that perspective coming into it, that they would be cautious in protecting their interests in whatever responses that they gave us.
One of the specific things you mentioned a couple of times was that the facility as designed, as laid out in specifications. Has anybody asked you for your guidance on what could be changed in that design that would maybe potentially put it in compliance with the land management code?
Not yet.
Open up for anybody else on the board?
And I would say that I'm perfectly happy to have that conversation. I would not want to have any conversation about that used in that discussion if that conversation was held here, because ultimately I would have to make a zoning interpretation based on a proposal, which I can't do sitting here. I mean, we can have a generalized conversation here, but any official determination would come outside of this forum with direct conversations with an actual proposal, with a back and forth and a written response letter.
Let me follow up on this question. You've obviously had cases where there have been interpretations of the code that the applicant maybe hasn't agreed with. They typically come back and ask for explanation and description of what could be done. Would that be true? They typically come back and ask for
Not all the
revisions?
time, but typically, yeah. But I wouldn't say all the time.
Mr. Chairman, if I can make a point to that, just to keep in mind, the administrative appeal was taken from the letter that says, and the decision that said this use is not permitted in this zone. So a lot of, like Steve was saying, a lot of the design features, spacing, labeling and usage of areas weren't necessarily, I don't think, really ripe for discussion at that point, because we got a letter saying that what my client interprets as and intends to put in there as a halfway house group home was not permitted in the neighborhood mixed use, which again, I think both sides are in agreement that a large, let me get this right, halfway house, large group home is permitted in the neighborhood mixed use. So I think, again, once the ball sort of got rolling with the appeal process and everything, yeah, we haven't obviously sat down with Steve to try to find some common ground, because we've got this adversarial proceeding.
And probably a good way to kind of summarize this, and Zach can agree or not agree, is my decision was basically a two-part decision. One, it was our understanding that it would meet our definition of a drug treatment hospital facility or a rehab center. That's not a permitted use, and that's pretty clear in the zoning chart. Then it came down to whether or not you all would make the argument that it was a large group home. And our position is what we see, and I reviewed, when I prepared that letter, I had benefit of seeing the floor plans, because this is all part of the building permit I was responding to. Our position is this does not meet the definition of a large group home in our ordinance. If they came in with a different configuration, we could have a conversation. And that assumes, again, that it's truly transitional housing of people who fall under those protected classes in federal and state law.
No disagreement there, and that's fair.
Steve, if I may ask, I heard you say, I thought I heard you say earlier that the building itself is not conducive to a home-like environment, regardless of the layout.
If I did, I misspoke. I can only respond, the letter is responding specifically to the building permit as requested. As they propose to modify the building, it's my position as zoning administrator, it does not meet that standard.
So the obstacle, to clarify for my simple mind, is the proposed layout.
Assuming that the people residing there fall under protected classes in state and federal law.
Thank you.
Just keep in mind, a drug treatment facility specifically is not protected by those provisions of state and federal law.
And that's not being proposed here.
Lori,
Steve, the only question I have that hasn't already been asked, you had noted under item number 11, there are only 6 parking spaces on the property. Isn't there off-street parking though that would be permitted for them to use as well?
The zoning ordinance, when you're dealing with the reuse of an existing building, unless there's a site plan that's been approved for the building, which in this case doesn't exist because this building was built in the 1920s. Generally, a reuse to another permitted use, we don't review for parking. In 99 times out of 100, it's not an issue. We don't have anything in the ordinance that says that we may look to actually propose an amendment, but there's nothing that specifically says that this type of use that you're introducing, it has to comply with current parking requirements. So this is a pretty intensive use that I'm going around Robin Hood's barn. Yes, there is on-street parking in that area. It'd be interesting to know how many cars that this facility would generate, but that's really we're kind of getting a little bit away from the zoning interpretation of whether or not the use is permitted or not. The reason why I mentioned the parking is more going to the definition of a home-like environment. Mr. Kiefer is correct. The zoning district actually does not specifically require certain yard space. But when you're talking about a home-like environment, we don't have a specific definition of it. The zoning ordinance, I have to use a reasonable interpretation of what constitutes a home-like environment. So I looked at the overall facility here and all the elements therein, and then I draw the conclusion whether or not this is a home-like environment. Parking, open space, the configuration of the facility, how it's being operated with such large staff, 24-hour basis, all those kinds of things went into that. Now, some of that maybe just a function of like some of the staffing, a function of the state licensing requirements. But the question is would anybody call this reasonably a home-like environment? It seems to me to be very dormitory, very institutional in nature, and very, very, very unlikely, if not impossible, to be remarketed later as someone's home in its current configuration or in its proposed configuration. Is that a home-like environment? I don't believe it is. That's not to say they couldn't come in with a proposal where they come up with something that could be, and again, we're not going to get into a debate here about details of that. But as it's currently configured, based on these plans that were provided with the building permit, this looks pretty much like a institutional use in the zoning administrator's viewpoint. And the zoning ordinance vests in the zoning administrator the discretion of interpreting the zoning ordinance, and there's no specific definition of home-like environment. So that's my interpretation.
Very good.
yeah.
No other questions.
Janice?
Nothing more to add.
Aaron?
I think everything I had questions on has been asked.
And if at this point, Steve, do you need to represent anybody else at this point?
For that, I am in the same position as all the folks here.
Yeah. Okay. So if no other questions, then we'll end this portion of testimony. And at this point, we can open it up to the public for question and comment and feedback. But I do want to clarify before we do that and be very clear, the only thing we're here to determine is whether there was an error made on the part of Mr. Bachmiller as the zoning administrator and not on whether there is anything else about this facility, whether it's right for the neighborhood, whether there's any other conditions you are concerned about. Simply, is there been an error made in the interpretation of the land management code? So with that, we have a large number of people in the audience. I don't know how we want to handle.
You have a sign up.
Do we want to go in order on the sign-up sheet? If so, we can start with Carolyn Moore. I believe is the first one on the top sheet I have. Carolyn Moore here. Okay. Then I will go to the first sheet. Dave Baker. Anything that Dave Baker wants to speak on? No. Okay. We'll move to the second name, which was Gene Shank. Anything that Gene Shank wants to? Third name, Steve and Debbie Hummel. Okay. If you do want to, please walk up to the microphone here.
I'm fine, Steve. That's okay. Oh, okay. I'm sorry. All right. First of all, my name is Steve Hummel. I live in the city of Hagerstown. I live on Mechanic Avenue. Thanks, Steve. I did have a question that I didn't. Can I ask a question?
Could you pull the
Yes.
microphone a little closer? Thank
How's
you.
that? Can I ask a question? What is your recidivism rate? How many people drop out of your program?
So we're a healthcare facility and we don't look at substance use as a recidivistic issue anymore. It's a chronic disease, just as an asthmatic and diabetic. I'm a type 1 diabetic. Sometimes my A1C goes up and I'm not doing so well. And then sometimes it gets better and I'm doing much better. And my doctor's really pleased with my progress. It's no different with a substance user.
So you don't measure a success rate of any nature or?
My doctor doesn't measure my success rate as a type 1 diabetic. Sometimes I'm healthier than other times.
Okay, understood. Well, then that'll come to my other point. First of all, I have nothing against the drug treatment center anywhere. The only thing that we have in concern here is very simple. And I have to, reiterate what Mr. Bachmiller has said, that it's very simple. It's neighborhood mixed use zoning. So a transitional center, halfway house is just not, it just doesn't fit. And since you mentioned it about a sickness or an illness, my opinion is then why isn't it out on Creighton Boulevard or out near Meredith, like where Brooks House is? That's where it should be. So I think putting it in the city is not the right direction. I think it needs to go out near a medical facility. As you mentioned, you even said it's a sickness or an illness and it needs to be treated as such. So that just further cements what I'm saying, that it really doesn't belong in a residential neighborhood.
It's permitted by the zoning ordinance for that district, irrespective of your beliefs or thoughts on where it is. It's principally permitted.
Well, that's between the two of you now too, as well. So, okay, that's really all I had. Thank you.
Thank you. Next name on the list was Courtney Lamb. Okay. Next name, Tim Miller.
My name's Tim Miller. I own rental properties at 802 and 804 and other properties in the North End. You were saying about investors having the skills and everything that does stuff. I'm sorry, but 802 was the first property I ever bought in this town. Guess what? The first call I made right to the city here. I want to know, is there any code violations? Is there this? Is there that? What can I do with this property legally? So I don't buy your excuse that you didn't do your due diligence beforehand. Sorry.
Is
And
this any at all relevant to the fact that whether or not?
well, yeah, because you said that because you're not an investor, you don't know how to do the due diligence. I'm calling it bullshit. Now, this right here.
So hold on a second. So number one, keep the language clean. And again, make sure that this is very specific to whether you have anything to weigh in on whether there was an error made in the
And-
interpretation of the code.
Right here, this is not home life. This is institutional. I could not buy that building and resell it as a multi-family unit. There's no way. It's institutional. That's all there is to it. The way it's configured, it's more of a dorm. And even Mr. Peacock on next door stated this was going to be a place for treatment. So what treatment center, treatment facility, treatment, whatever, he's even stating that it's going to be a treatment for treating people. So here we come back again. That does not fit in the zoning as a treatment facility.
No objection there, it's a halfway house.
Then why are you saying on next door?
I didn't say anything about that.
Well, Mr. Peacock did. He said treatment. So, and I'm sorry, you got almost 1,000 square feet of space unused. That to me means that, okay, you get this facility 3 months from now, you're going to come back and say, hey, we'd like to get a variance down to do this other stuff. And everything that
You
would
can't
not
get a
be,
variance for that.
that would not be within the zoning.
It's not permitted. You're absolutely right. You can't.
Mhm.
No variance, nothing.
Well, we'll see about that, because I know too many times people come back and get variance for different things. So,
Staff could provide a little bit of guidance on that. A drug treatment hospital, rehab center, et cetera, where it's treating people with the active and the front end of the addiction is not a protected class. It's treated differently than halfway houses or group homes. These are uses that are listed in the land use chart. It is actually against Maryland state law to grant a use variance. Variances are strictly for building height setbacks, et cetera. You can, unless it's written in as a special exception in the use chart where they have to come to this board for approval, that is the only way to do something like that. And our zoning ordinance does not permit a special exception for that use in the zoning district. So Mr. Pieper is correct that there is no variance that is root within zoning that would allow for a residential treatment facility at this location. That is above our definition of a group home within the ordinance.
So before I call the next people up, just a reminder, this is live broadcast online. Anybody can listen to it. So please keep the language clean and make sure that the items you're talking about are relevant to the specific matter at hand. With that, we have Tyler and Julie Honreiter. Have that pronounced right? All right.
Really quick question. So I think you mentioned that you don't administer, and I'm just going to say it right, Suboxone and Vivitrol. Is that correct? So there are doctors in our community and that we have partnerships with that prescribe the medications to our patients. Okay. But once the patient has the prescription in their hand, it's their medication. So Wells House does not have medical providers that prescribe it. We partner with community physicians that prescribe it.
And what is the role of those medications in terms of the withdrawal process?
So sometimes they can be started at the beginning to help prevent the withdrawal from happening, but they're also Suboxone in particular, Vivitrol also for that matter, is prescribed later after the withdrawal has occurred because somebody is experiencing intense cravings. And so they have been known to help with that intense craving. And so they can be prescribed after the withdrawal process has taken place.
So it would be a post-detox scenario.
It can be, yes. It's used in both instances.
Okay. Okay. The other point that I guess or question I had is what stops, based on the amount of rooms, particularly unused rooms labeled on the map, what I guess prevents someone from adding extra people to those spaces? Are there inspections to be had and things like that? how do we know it's going to be used for what it says it's going to be used for?
I can speak from the state licensing board. When the fire marshal comes in and provides then the use and occupancy, typically they have a maximum number of people that can be in that building. Your state license is tied to that, whatever that number is. And so then when the state comes in to relicense, when an accrediting body comes in to kind of re-accredit, they look at all of that. And so for us operating as a licensed facility in the state, we could not do that.
There's also oversight from the planning.
Okay.
Because there is a 10 to 16 resident restriction for large groups. So there is a local enforcement.
But you're gonna let us in?
If you're not, very good.
Well, I think that was more my question from a practical standpoint of the inspection process. And then I guess just a last point, kind of piggybacking off the idea that I don't find this a home-like setting at all. I agree, it's way too large. From someone who's lived in, this equates to me as a college dormitory setting where, you know, you don't have, yeah, sure, you live there, but it's not really your home. You don't have your own kitchen. You share a bathroom, whether or not they're, you know, single stall, multi-stall, or whatnot. You come and go and you do your business, but there isn't that that home-like atmosphere. So I do agree with that. That was just a point of support on that end.
Thank you.
Thank you.
Next is Charles, is it Monaghan? Is that correct? Charles Monaghan, it looks like, on Antietam Street. Now, Charles Monaghan on Antietam Street?
Mooneyham?
Mooneyham, okay.
I think he hasn't started. You don't have that.
So Christina Trenton? Sorry, it was you. I apologize. Roger Bushby. Yes. Nathaniel Peacock. Larry Engel.
Yes.
Hi, my name is Larry Engel. I live at 328 North Locust Street, which is next door to the Wells House on Locust Street. We purchased the property, one family of a two-family unit in 2007 and moved full-time in 2011. So we have a history with Wells House. And when we heard that Wells House was going to sell and move up to the proposed new facility, we were appalled. They've been our best neighbors in the neighborhood, other than maybe one other person. They are respectful. They are working hard at what they are trying to accomplish, and not all succeed. We know that. We also know that they take good care of us and our dogs. When one of our dogs got out of the yard, they would come knock on our door and tell us your dog's out, and we held them. They're the only neighbors who shovel our walk in the winter. They won't take anything for it. So I think that there's a misperception of the people who are there. I have more complaints. We have more problems with street traffic. Pedestrian traffic late at night, early in the morning. We have more problems with noise from other neighbors than anything we get from them on occasional problems, which occur always. In terms of what a home is, I would like to comment about the design, which I hadn't really seen, but based on what you presented, we live in a very small home. We, in fact, rent the next house because our neighbors had been so awful over the years that we took it upon ourselves when the last tenants were evicted, we took over the lease for self-preservation. We lived on a farm for 16 years. We had 7 bedrooms for 3 people. It was spacious. Actually, then 2 people, my spouse and myself, yes. And it was spacious. We now live in a 2-bedroom row house. It's small. But to say that the design per se is not a home, I think may be accurate, but it's home-like. The Locust Street Wells House can be a home, but you're right. People, as other people said, people come and go. It's not like they have their own bedroom. They don't have their own kitchen, but it is in the community. It's not out isolated. And that's the whole point of being in a community, being supported. And if you just go down Potomac, you go down now Dual Highway, out towards Greenbrier, you have McMansions. They're huge. So having a spacious open room for clientele seems to me to be an awfully nice possibility. Thank you.
Thank you. Carolyn Moore?
Hi, that was my husband. I live in the same place, 328 North Locust Street. And I have to tell you that the Wells guys in that house are the best. They are helpful. When I'm taking groceries out of my car, one of them walks past, hey, let me help you with that. Let me help you with that. When we first bought our property, we were only here part-time. They shoveled the snow when we were not here so that we would not get in trouble with the city for not shoveling our sidewalk after a snowstorm. They took care of everything. My husband is a documentary filmmaker. He travels. He would leave me sometimes for weeks by myself living there. And the guys over there would check on me all the time, make sure I was okay, make sure I was feeling safe, and asked if there was anything that they could do for us. And they've just been incredibly hardworking, and they're very open about what they're going through in terms of their addictions. A lot of times we have long conversations with different guys over there, and it seems to help them to be able to talk about it. It seems to help them to be able to be in a neighborhood where they are actually told that they should try to be good neighbors. And they're really great. And we're very sorry to see them go. I think our dogs were good therapy dogs for them too, because he would spend a lot of time patting them, throwing balls for them in our yard and doing stuff. And if it, like he said, if a dog got out, they just come right over right away. Our dog usually would get out and just go over to Wells' house because they were always looking for attention. And guys were always out in the yard. So that's where they went. But they've been really great neighbors. And I think they're a great group of guys. And that's all I wanted to say.
Thank you. Next is Patricia Homan on the terrace. Sorry if I got that last name wrong.
I live at 1424 on the terrace. And this wasn't my initial question, but I've got to ask, if you've got such wonderful neighbors, why are you moving?
The house is very old and it's small. We can't provide the space that we believe our patients deserve. And a larger building would allow us to do that.
Okay. How many people do you have currently?
We have 16.
And you want to still have 16? You just want more room.
We do.
My real question had to do with, you've got staff. How many staff do you have, like per shift? I'm guessing you have like a day, evening, night, until.
We do. We have 3 shifts. We have minimally 1 person, and sometimes those appear with that person, so sometimes there are 2 on a shift.
So you usually have about 2 people per shift?
1 to 2, it depends.
So 1 person for 16 people. I used to manage a nursing unit at NIH. So you've got 1 person for about 16 people. Who does that person call if they need support or help?
So we have an on-call system, and so one of our clinical staff are on call for a whole week at a time. And so that's the first line of defense. They call the on-call staff member. If that person or that clinician can't help, then they call the clinical supervisor, and then we have a clinical director. We have a facilities maintenance person.
How far away do they live then to make it in? What, fast enough?
I think the furthest that, like, our facilities maintenance person lives in Walkersville.
Okay.
The large majority of our staff live in Washington County.
My next question that speaks to, you talk about being a home environment and people can come and go. You've got 16 people. Are they allowed visitors that can come? Do they have family that can come in?
Pre-COVID, yes.
Okay. So I'm wondering if you lock doors at a certain hour, if it's a home, are people coming and going day and night?
So we have curfew requirements. We do have men that work 3rd shift jobs. So they are permitted to be out of the facility outside of those curfew requirements, but the doors do not lock. People can leave at any time.
So 16 people can come and go day and night?
They can. We have rules.
My home doesn't do that.
Correct.
It was never able to do. My children were never able to do that.
But as I said, we do have curfew, and we have the expectation that our residents are in the house by curfew. And if that doesn't happen, then we try to deal with that with their clinician. And we do have men that work 3rd shift jobs.
Right. Can you have overnight guests?
No. No.
I
overnight
don't know. I'm just asking.
It's a good question, but no.
Okay, so family can come and go, no overnight guests.
Family have to be approved, and we have a visiting policy, visiting hours. And then
Thank you.
Becky Holman? Robert Powell?
No.
Mark Meany?
Pass.
Randall Moran?
Pass.
Robert Noggle?
No.
So that's my name, Robert Noggle. I live in this neighborhood. Some of my neighbors are here. And first of all, I'd like to say hello to Chairman, Commissioners, Bob Miller staff, representatives of Wells House, and to the people who are virtual. I would like to know how many people are watching this, just because we do have an audience here, and I can't tell how many people are here.
I don't know if we can tell how many are online watching. We do have 1 participant that's dialed in, that does not have a name.
Do we have a number or not? No, okay. So, I want to support Mr. Bachmiller's decision, which I think was the correct decision. When I learned of this issue, I made some attempts to inform myself, and based on the reading that I did and the interchanges and the information that was presented in the sheets here, the record sheets, I realized I don't know a lot about this. So I stand to be corrected if I make some wrong presumptions. The thing that struck me first, as I say, I was born and raised here. I lived in a neighborhood. The thing that struck me first was a year and more, 18 months after the rezoning work was done. Wells House paid quite a bit of money for this property. But they paid half again as much as its assessed value for next July. And the next conclusion is the only way it's going to be worth that is if they get this zoning variance, which I think they should not get. Pardon me?
It's not a zoning variance.
Okay, please tell me. What's the issue? What's the correct terminology for the issue here?
Whether the zoning administrator.
Whether it
is correct.
complies to the zoning. Okay, so I think it does not comply. And as an aside, I might note that the commissioners serve at volunteer level. It's a tradition in this community. Town was founded in 1789. It's had many iterations, but there is a culture here of volunteerism. We get high quality people, even though we disagree with them often. Mayor and city and council are not getting rich, as far as I know, by the pay that they get. So they did due diligence on this zoning. It wasn't haphazard, and it was there for a reason. So just in particular, the idea of a home environment, family environment, the only way that that's true is in a euphemistic street sense of the word. Go out and you meet with people who are randomly associating with you and you call them brother, and it's a good thing. It's a good positive thing to establish some sort of a relationship. But this is not a family environment. And I'm really glad that the commissioners and others developed the idea of how exactly these tenants or boarders or clients of Wells House are going to arrive there. And they come from various and sundry ways. I've heard of a judge in Baltimore. This may be an urban legend. A judge in Baltimore actually sentences people or requires them to come to a treatment facility in Hagerstown. It's happened at least once, I think. Local judges around the country give opportunities to people for making a choice. You know, if you go into rehab, this is an alternative to actually doing jail time. And I'm going to be motivated if that was my condition, and I'm empathetic. However, there are plenty of places in this city, zoning, that will provide for Wells House, and I'm empathetic to Wells House's position now. That, as I say, I was somewhat shocked that they were so confident of doing this that in January of this year they laid the money down and made the money, paid the money for engineering, and developed this plan pretty far. And if I were Wells House staff and executives, I would be really concerned about this. And you know, I'm not happy to say that I don't want you to do this. And I know that there are people in the neighborhood that feel it's not because we don't believe in drug treatment. There's plenty of it, and we're probably going to need more because of the national culture, availability of narcotics that are 1,000 times, 50 times. I've heard those factors stronger than anything that was ever on the street in the 20th century. And these cause serious chemical changes in the bodies of people who use them, and they need treatment. And it's not for a lack of investment that I lost my thought there, but in any case, I don't want them to do it in this neighborhood. It will definitely change the face of the neighborhood, and it's not needed there. So I'm not too articulate, but that's what I have to say. Thank you, Mr. Bachmiller, for the good work you've done. Thank you.
Stephen and Jill Salas.
Stephen Silas. I reside at 932 Oak Hill Avenue. A couple of questions, or I should say a couple of comments. You indicated that there was no recidivism rate that you're using in your organization. Is there a national recidivism rate?
It really isn't. That is the way that we used to look at this this disease, or if somebody could just stop and then they stop once and that means success and they never have to be treated. It's kind of treated like an acute disorder. You break your arm, you go to the ER, you get your arm set, your broken bone set. You don't have to come back. Everything's good. This is now looked at as a chronic disorder, just like asthma, diabetes, heart disease. We don't have recidivism rights for those diseases.
You did indicate that there was no security. None of your staff is security trained. The doors are unlocked. Your patients are free to come and go at any time. Yes, there are maybe protocols for them to leave, but that may not necessarily stop someone from leaving in the middle of the night.
Correct.
Okay. You had made the question to Mr. Bachmiller about living in a family setting or a group setting, whether he had that experience or not. He did not. I have. It's called the United States Army. It wasn't home. Thank you.
Thank you. Next on the list is Nate Mackey.
Nate Mackley, I live on Oak Hill Avenue. I think you stated there are currently 16 residents on Locust. Okay, thank you. My question for the city is, would this be a clear-cut case of no questions that this is not in zoning compliance, that there are more than 16 potential residents?
The use is capped at 16.
Okay. And then would that cap play into a fire marshal setting limits on occupancy limits?
Yes.
Would more detailed plans and changes coming from Wells House make it less institutionalized and then lend it towards compliance in that case? If they were to make changes to the plans, could it look more like a home and then be more likely to be in compliance? And I understand that's an opinion.
It's an opinion, and I don't want to get tied down to anything because what happens is we respond to a proposal. If for some reason the board would find that, okay, it's not a drug treatment facility, but it is a group home, which allows up to 16 people, but this particular configuration doesn't work, then the next step would be that we would have a conversation with them. And we would mostly operate on a response to proposal basis.
Okay.
Give us a proposal, we'll take a look at it, we'll see. We tend not to sit there and try to, you give us that, we'll take that, some sort of negotiation. We respond to proposals. I will characterize saying the changes would have to be substantial.
Okay.
In my opinion, based on what I know now.
Okay. And then does this particular case point to the need for further clarification in the NMU zoning, in your opinion?
No. I think it's as clear as circumstances are going to allow, given the federal laws and state laws that deal with protected classes.
Okay.
There was a ton of research that was done into this by the planning director back in 2017 and 18 when we were going through this. And it was looked into in great depth, trying to figure out what works for the community, but also at the same time remains compliant with state and federal law, so the city doesn't get sued. The tax dollars are spent defending a federal court case.
Yep.
So.
Okay. Thank you.
Thank you. Alexis Peacock. Okay. And lastly, Mr. Bachmiller representing the Planning Commission.
Yes, I'll rely on my previous swearing in. I just want to enter into the record as respondents exhibit, I guess that's 2. Respondents exhibit. It's a memo from the Hagerstown Planning Commission. As zoning administrator, I staff 3 different boards, this board, the Planning Commission, and the Historic District Commission. And they asked me to represent them at this meeting and provide the following memo. Dated August 16th from Douglas S. Wright Jr., Chairperson of the Planning Commission. The Planning Commission has reviewed the pending administrative appeal filed by Wells House for the property referenced above, which is located in the NMU zoning district. In that application, the appellant disputes the zoning administrator's determination that a rehabilitation facility for drug treatment is not a permitted use in the NMU zoning district, nor is a halfway house as proposed and configured by the appellant. This commission registers its support of the zoning administrator's determination and enters this memorandum to the record as such. In the recent past, staff in the planning and this commission worked at length to revise the city's zoning regulations regarding these uses in a way that, one, provides sufficient locations within the city for these uses, two, directs them into appropriate zoning districts, and three, is compliant with state and federal laws which govern these uses. Significant research by staff and the city's legal counsel over an extended period of time resulted in the regulations as they currently exist. We are comfortable that the ordinance amendments as adopted by the city and applied by the zoning administrator are legally sufficient. Treatment facilities do not receive the benefit of federal or state protections that supersede local zoning laws. Post-treatment residential arrangements do receive certain protections, and the city's ordinance is compliant with those provisions. In an inpatient treatment facility, an inpatient drug treatment facility is not permitted in the NMU zoning district. Post-treatment housing is permitted in the NMU district under certain conditions and circumstances of which this proposed use does not comply. We authorize the zoning administrator or such person as he may designate to represent him in his absence to represent the planning commission in this matter, and authorize him to present this statement to the board and enter it into the record of your proceedings. Thank you for your consideration.
Put that in the record as response number 2.
I'm sorry?
Put that in the record as number 2. Is it number 2?
I believe so, yeah.
Okay, at this point, then I would thank the public for the comments, thank both the appellant and the respondent for their willingness to answer questions of the public. And I believe at this point we can close all testimony and
Might want closing statements.
closing statements, sir. Yes, apologize for that. Closing statements now. So with the appellant first.
Very briefly, Mr. Chairman, again, we're here, I would submit first that we're here on that initial circa June 23, 2021 denial of the building permit based on the fact that Mr. Bachman stated the use is not permitted. Obviously, we dispute that. I think it's well established that a large group home halfway house is permitted in the NMU district. On that specifically, I would submit that the zoning administrator was in error in making that decision, and his decision should be reversed. More broadly, and what took up all of the night was the characterization of this as not home-like. I think in general, there's a lot that goes into home-like. This isn't a home environment. It's a halfway house. They're trying to get home. But there is a home-like environment, even if we're going into an old commercial building that the neighborhood mixed-use district encourages the adaptive reuse of these old buildings. You've heard some neighbors of the current location of the Wells House on Locust Street saying, by all of as much as I can glean from it, that there is a home-like environment going on there. They're helping their neighbors, they're shoveling sidewalks, taking care of dogs. And there's a lot that goes into feeding, clothing, laundering for 10 to 16 people. Obviously not as big as an army barracks. Obviously not as intense or in the same vein and flavor as an inpatient rehabilitation center. But there's a lot that goes into it. There's a lot of extra space in this building, and that can be, who doesn't want extra space in their residence? There's going to be food storage, supplies, things like that. It's just a matter of fact for 10 to 16 people. So any sort of characterization you dispute as this not being home-like, it's not just the aesthetics, although they're certainly important, but it's the ability of the residents to interact with each other. There's communal dining, there's chores, a lot of things that go into creating that home-like environment and not sitting in your cold institution, waiting for the nurse to come around with your food and things like that. So with that, even if there are some size, concerns, we still have to go through a site plan approval process or still get those approvals from the city. There's time to work on that. But ultimately, when you go back to the question, is this a home-like environment? I would submit yes. Is this use permitted in the neighborhood mixed-use district? I would submit yes. And I thank the board for their time and the thoughtful effort.
Thank you. So closing from the respondent.
I'll be brief. Being that it's already 9:30. What you have is a couple of questions in front of you. What is this use as compared to the definitions found in the zoning ordinance? Is it a drug treatment hospital? Is it a rehab facility? Is it a large group home? Did I determine that correctly? In the zoning ordinance, let me back up for a second. When we deal with a client, in this case, Wells House coming to us for a building permit, we try to give them as much information as possible. And it was gray on exactly what it was that was being proposed to us. We heard that earlier in the thing. So we provided a response. Here's response number one. And then if for some reason that's not correct, here's response number two. That being the configuration of it as a, whether or not it's home-like and meets a definition for a group home. It's our understanding based on the information we had available to us that this was more than a group home. And as such was not permitted in the zoning district. That's going to be one of the questions that you're going to have to weigh. And the second question is, okay, if you all decide that that's not the case and this is a group home as defined in our ordinance, not Comar, then the second part is the determination I made, but it doesn't meet the definition. It would need to be significantly reconfigured to be allowed this location. To that, I simply respond to the zoning the ordinance vests in interpreting the zoning ordinance to the zoning administrator. And unless there was clear error, it's incumbent upon this board to support the position of the zoning administrator in debatable cases, assuming that you determine that it's debatable. And I think that's all I have.
Okay, thank you.
Just trying to keep you focused and keep what the issues are.
Thank you. With that, we can now wrap up proceedings and we'll move into our deliberations. These deliberations between us, nobody else can comment.
Mr. Chairman, there's somebody who is signed up or is dialed in who's on mute, and I'm thinking we better double check to make sure that they don't have testimony they want to provide.
Apologize, sir. So there's a caller or somebody that's on the call that number ends in 663. Could you please identify yourself and whether you want to make a statement?
I know they've been on the call the whole time.
Yeah.
Oh.
Am I unmuted now?
Yes, you are.
Yes.
Yes, my name is Nancy Allen, and I would like to make a comment. I was unmuted, or I was muted prior to now.
Yes.
Ma'am, could you spell your last name and give us your address, please?
Yes, Nancy Allen, Allen, 924 Oak Hill Avenue, Hagerstown, Maryland.
Thank you.
What would you like to say?
I would just like to commend the zoning administrator's decision to deny the request for the approval by the Wells House. I feel that the current zoning of NMU does not allow for this proposed use, as noted by the zoning administrator. I'd also like to state, after listening to the complete meeting here this evening, that as a homeowner, I feel that the that the city zoning code is a homeowner's protection to maintain the integrity of the neighborhood. If we don't have zoning and zoning ordinances to establish the integrity of the neighborhood, then we do not have anything. And I feel like as a homeowner, this is what we rely on from the zoning administrator, and in their decision, I would support their denial to request the approval by the Wells House.
Thank you for your statement. My apologies in not including her previously. Does her statement give any party the desire to make an additional statement?
No.
Okay, apologize for that error. With that, we will close all testimony. We will move into the deliberation stage. This will be between the members of the board. You can stay, you can go. This will be private between us, no other comments. And once we make a decision, that'll be put in writing and sent out within 45 days. So with that, we'll move into conversation about the topic at hand. And we'll take just a second as some people move so that we don't have the extra noise.
That's its use, and they're not making any changes to the exterior of the building, so you have no role. Okay.
I will ask if you're going to be in the room, if you could keep the noise down a little bit as we do need to deliberate.
Folks, if you're going to stay and converse, please take it outside, please.
Okay. So where do we want to start?
Area and yeah, describes what
Yeah,
the description for
Half an hour or something like this.
yeah, the only two really relevant pieces here are 319.
This whole meeting, including their deliberations, will
Section 319 and then the definitions under section 4, starting at 443.
Thank you.
Right. Because it's obviously been stated that it is the NMU, right? So we know that. So it's so really, if you look at the code, if that section starts on page 4148. So really, the only two sections relevant are that section and what's on 319.
Okay, you ready to start your deliberation?
Yeah. Yes.
Are you ready to start? Okay.
Okay. So our main question is, was there an error? So based on the definitions in the land management code of
Jimmy, you're going to want to speak up so they all can hear you.
Sorry. Can you guys hear me okay?
I can.
I can hear now.
Yeah. Okay. So the key thing is based on the definition within the land management code as outlined on page 319, is in the documentation we have, was there a misinterpretation made of whether this property can be in this particular zoning area? You guys want to weigh in on your feedback so far? What your thoughts are?
What was your question? I'm sorry. What was the question?
Do you want to weigh in with your feedback, just initial feedback on what you think based on whether it meets requirements as outlined in 319?
You mean as far as Mr. Bachmiller's decision?
Yes.
Oh, well, I feel that he did not make an error in his decision, and all the facts actually are legally sufficient. So, you know, everything was in order. That he did not make an error in the decision.
So do you specifically feel that the way the facility is outlined and the way the evidence was presented, that it does meet the requirements specifically for a halfway house?
No,
And
I'm
it does
saying,
meet the requirement of being a residential-like facility? Or not?
I feel that Mr. Bachmiller made the right call in the report, in his report.
Aaron, do you want to weigh in?
I mean, I'm just reading over the definitions. And am I wrong in saying that they're licensed by the state of Maryland as a group home, halfway house, and alternative living unit? Is that what I'm seeing on Exhibit B 205? I can't tell. It's like the first page is missing from that in mine.
Right, and that didn't come up at all, did it?
So on which exhibit are you looking at?
Exhibit B, page 205.
Page 2.
It's stamped Exhibit B. It says registration 10/9/06/04.
Oh, Exhibit B, B as in boy.
Regulation. I mean.
Yeah, which is in the packet. Right.
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 So I believe that'd be the interpretation, but this is part of the Comar code, which isn't necessarily relevant to what we're talking about.
Okay, I thought it was alluding to that there were actually, it's the code's definition of a group half. Okay.
Okay.
Right, but I believe the issue with using this is defined as whether they can be licensed to do this versus whether they have the ability to do the land management code within the city. So the definition within this document doesn't necessarily apply to whether they can put the facility as they've outlined or described it. So Greg, do you have any comments?
Well, Jim, I think the handout that Steve provided that I'm looking at a copy of comes down to the last paragraph. I mean, this is where we need to make our decision.
And this is responding to Exhibit 1.
You mean
The
number
handout-
15?
Yes.
Mm-hmm.
Well, no, the last paragraph, okay. The role of the board is to hear appeals and determine whether a zoning administrator erred. Okay, I cannot say that Steve erred. All right, yes, there is, they did a lousy job in putting this thing together, number one. That's what I think it comes down to. Steve had no other choice but to make the decision that he did based on the information that he had. So I would agree with his decision.
Correct.
Sure.
I concur with Greg and Janice.
I would agree. I would say that as based on the challenges of what was provided material-wise, what did or didn't happen, and doing follow-up ahead of time to investigate, the code itself, the very little information provided, and based on what was provided, the interpretation of the facility as outlined and described, especially referencing another facility in use currently, doesn't match to what the definition is with land management code. So it sounds like all of us are in agreement that there was not an error made.
Correct.
That be correct?
Correct.
Correct. That's correct.
Okay. So based on the interpretation of the documentation provided, based on the information that was given as the permits, based on the lack of detail around the intended use for the facility, based on the testimony given tonight, we would state that there was no error made, and with all relevant information provided, the decision would have been the correct decision in our minds.
This is for the initial determination, and I want to make sure I don't testify here. I'm just asking clarification for the record. What you're saying is the initial determination that this is a drug treatment facility or rehab center as defined in our ordinance, not a group home.
Let me,
Is that what you're saying?
not exactly what I'm saying. Now, what I'm saying is based on the information provided, there could be no determination that it was a halfway house. And you would have to default to the fact that it would not necessarily be a halfway house based on what was provided. I think that using specific language there. So
I think as Steve said in his final paragraph, it is debatable. Therefore, if it's debatable, we have to agree with Steve's decision.
Correct.
Right, he did, right. We were supposed to see if he erred in his ordinance, and he did not.
Okay, so let me take a stab at how we wrap that up. So based on the information provided, the decision that was made by Mr. Bachmiller on whether this was allowable within the zone was not an error. He is declining it or saying that it could not be allowed within the zone is correct.
Correct.
Based on what was provided to him, and there's no other determination he could make. So in that case, we're going to uphold what his decision was.
Correct.
Does somebody want to make a motion to that effect?
Chairman, question for you. The document that they're appealing is a two-part decision. And I just want to make sure, and again, I'm weighing my words very carefully because I want to make sure I'm not trying to influence you here. The first question was, what is this? I determined that it was something more than a group home. And it sounds like that is the position of all of you in this meeting. And the second question is, if it is a group home, then it doesn't meet the or if that's their intention and they think that's what it is, that it doesn't meet the definition as it's configured.
Correct. So
now the second part, if you're coming to the conclusion on the first part that I was correct, does it make the second question moot? In other words, I think you need to address both elements to it in your one way or the other. And again, I'm not trying to influence you. I just want to make sure we have a legally defensible motion and decision that we produce from this. So you may want to make sure you have a very clear and concise motion, clearly addressing both elements of the appeal.
okay, so who wants to make the motion?
I think we need to have some verbiage ready before we make the motion here.
So I think that the motion needs to include the fact that we have agreed with the fact that as presented, the facility does not meet the definition in the land management code of what a group home would be. And it was not an error in Mr. Bachmiller's part in making the statement that it does not meet that requirement.
Well, you know, it's obvious to, excuse me, it's obvious to me that this is a group home. Okay. So I think the failing here is that it is, because of the way it's configured, it is not a home-like environment, which is part of the definition of a group home. Am I wrong in that assumption?
No, I agree with you. I think it's a group home. It just doesn't fit the qualifications of the home like, and it needs to be reconfigured. That's my opinion.
Right.
So who can package that up in a
Well,
motion?
then what we're saying though is Steve's first assessment that it's not a group home is actually an error.
No, that's not what we said a minute ago.
Well,
are we wavering on that now?
That's what I said in the beginning. That's why I was looking through like the Comar definitions of what is a group home.
Right, but we need to look at the land management code's definition, not Comar's.
Well, I
code.
understand. I was looking like what's a group home to the state, and then if it qualifies as a group home to the state, but maybe not for the, I don't know, maybe not for the zoning as far as the land or the configuration. That's where I was at with it.
That's exactly where I am.
Because it is a large group home or halfway house that accommodates 10 through 16 residents. We all agreed to that. And it's a multifamily residence. It's allowed to be where multifamily residents are allowed. It's just it's just not laid out properly, right? Doesn't have the
I know.
Okay, so what we kind of said a minute ago, and I'm not trying to steer you guys, but what we said a few minutes ago was that this was not an error on interpretation because based on the information provided, the use and purpose of the facility was not clearly defined, so you could not make the assumption that it was going to be a halfway house. So that is why there's not an error. You did not have enough detail in what Mr. Bachmiller had in front of him. Vision that yes, this would be a halfway house. It did not appear to be a halfway house. It was not outlined as a halfway house. He didn't have that information available to him. So if we agree that he didn't have enough information to make that decision any other way than what he did, then he did not make an error. So I guess let me ask that question.
I would agree with that.
I would as well.
Well, I would too, but Steve brought up the point that we have a two-part decision.
Yeah, true.
So I was ready to agree on that part of it, but Steve brought up we have a two-part decision.
So how would you answer the second part?
Well, let's define the second part. What is the second part? Is it
Staff would point out an option. Once again, I weigh my words carefully. If you decide that I was not in error for the reasons that you discussed, and this is based on the information available, appears to be more than a group home, one of the options would be that you just make your decision based on that. And if it's determined to be a group, a hospital or rehabilitation center based on the information provided, then one of your options on that second part is to dismiss it or to not address it because based on your information, it's not a halfway house, so it doesn't matter how it's configured.
Right. It's irrelevant based on the answer to the first one. So that's
So an answer on number two could be yes, no, or immaterial based on the response or your decision in question one.
So based on all this, will they be able to do anything? Do they have to take up everything that's been done?
I'm not sure that's
because they did. I mean, they didn't do their due. Let's face it, they didn't do their due diligence from the very beginning.
Correct.
Yes, and I'd say that's up to them if they want to come back to us, but I don't think we need to.
I mean, you know, and the attorney, I guess he was the attorney, was, I mean, he just kind of danced all around that.
Yeah, I don't think we need to debate that now.
Okay, so would somebody like to make a motion then that says based on the information that was made available at the time that everything was submitted, that Mr. Bachmiller had in front of him at that time, that his decision that this was not qualified for the zoning area based on the fact it's not a halfway house, that was not an error, and that decision makes any other request around this moot. There's no other detail that needs to be provided.
You've just made the motion, right? It sounds like.
Somebody else needs to make the motion, but they can say that they want to make the motion in the way that I said it, or something close.
I'm sorry. Jim, if you would like, I will make the motion. And we accept the motion as you stated.
Do we have a second?
I second.
Okay. So then all in favor, say aye.
Aye.
Aye. There's all an aye, so there is no, that's unanimous. There is no negative. So at that point, we're on agreement. We wrap that up. The motion carries and we can be done, I believe.
Business item.
Okay.
So that passed 5-0.
5-0. There was no error made. And the second point is moot based on that decision.
So that means we'll hear from them again, right?
They do have time to appeal.
Or they can come back and work with us and figure out something.
Right. Sounds like that was the path from the talk anyways.
Other business, we just had one item that we would like to discuss with you. With the recent retirement of our 4-decade administrative assistant, we're kind of relooking how we do certain things in the office. And one of the things that we would like to discuss with you, and we don't want to pressure you one way or the other, it's your call to make this your meeting. But we as staff stay up 5 after-hour meetings a month. 2 planning commission, 2 HDC, and 1 for this body.
I can't hear you, Steve.
Okay. Our staff, planning staff, staffs 3 different boards. This one, Historic District Commission, and Board of Zoning, Planning Commission. HDC and Planning Commission both meet twice a month. This one meets once a month. It's 5 after-hour meetings. Every one of them is on a different day of the week. We're looking for ways to possibly consolidate some of that. And one of the things we wanted to run by you, again, Dr. Herder feeling to decide to stay with status quo, is in the 2022 cycle, when we adopt a new meeting schedule, would you be willing to consider moving your meetings to the same night as the HDC has their first meeting in the month, which is typically the second Thursday of the month? Would that create any conflicts for any of the existing members of the board? So what we could do at that point, the HDC meets at 4:30. We could have the HDC meetings that typically don't run more than an hour. So we could do our HDC meeting and our BZA meeting the same night, one night, meet the staff knows that they're not. Again, it creates a scheduling problem for any of you all, it's your decision to make, but we thought we'd throw it out and see what we thought.
So the first meeting starts at 4:30, takes an hour, so we would start immediately after that. I start at 7 o'clock.
7 o'clock, and that gives us BZA, HDC meets at 4:30, so it's 2.5 hours to get the HDC business done, which we almost never have a meeting because we literally never have a meeting. Some of them are rules 5 minutes, others like last night.
Second Thursday
Second Thursday, typically, yeah,
at 7?
at 7, yeah.
That actually works better for me. I have late meetings on Tuesdays and Wednesdays.
Yeah, Thursdays are fine for me as well.
Yeah,
They're good for me too.
no issue.
Right?
I'm retired. I can meet anytime.
I'm retired too, but I have another schedule.
Because in the next couple months, when we present you your proposed schedule to adopt for 2022, we'll base it on, and that includes the deadline for all the adjustments as well, to where your schedule will be. And it's actually one thing to work out better for us too, because the county will be the same thing.
Right.
So if we have issues with an attorney with clients, so in front of them, in front of us, stuff that happens part of the other, that can be a little bit better. Okay. I would just as a clarifier, there's a couple of city agencies that would double check with as well. Make sure that we, all right.
sounds good.
But then you would get us a new calendar.
Yes,
Okay,
yeah, and we'll stick with the existing third Wednesday through the rest of this year, so
Okay.
October, November, December, we'll still stay with the adopted schedule. Okay.
Okay, with that, if there's
Very
nothing
good.
else, so we'll make a motion to adjourn.
I make a motion that we adjourn.
In a
I
second.
would definitely second that.
All right.
It's past my bedtime.
We're all in agreement on that.
Good night.
Good night.